The fun and interesting things, and the thing that makes it so challenging to be in HR or to be dealing with employment law issues, is that there's a new wacky challenge every day, because, as I always say, people are people. And so we're always happy to, be your partner in dealing with these issues and advise you and help you get through those tough days. So I'm going to kick it off by introducing Larry Casey. Larry Casey is a partner in our employment law group. And then I think we've got Emily Crowley and then Robert Kaitz, and then I'll be back.
So I'm here to talk about non-compete agreements. So I'm sure some of you know, some of you may not know, Massachusetts passed a Non-Competition Agreement Act, which impacts what non-compete agreements can look like in Massachusetts. And there's been some significant restrictions, and it impacts employers in significant ways because of, if you don't meet the requirements, the non-competes aren't going to be enforceable. And in some instances, particularly without cause termination, it's not going to be enforceable. But let me go through it in more detail. So first of all, the Act covers non-compete agreements that are entered into after October 1, 2018. So if you have existing agreements that were entered into prior to that, those are all still valid. If they don't meet the requirements of the statute, it doesn't matter, they're still enforceable. But it's everything that were entered into on or after October 1 that has to comply with the statute to be enforceable. So what is a non-compete under the Act? A non-compete under the Act is an agreement that provides that an employee will not engage in certain specified activities that are competitive with the employer after the employment relationship has ended. Interestingly, the definition of employee under the Act includes an independent contractor. And as some of you know, I'm sure, it's hard to be an independent contractor in Massachusetts. There's another statute. You have to meet 3 requirements in order to be one. But if you do, and you have an agreement with an employer or a business, and there's a non-compete in it, it also has to comply in order to be enforceable against you, or if you are the employer who has hired or retained that independent contractor, to be enforced against the independent contractor. So I'm going to start first with what it doesn't include, because there's a large subset of what a non-compete is not considered under the Act. It does not include agreements not to solicit or hire employees. It does not include agreements to not solicit or transact business from customers, clients, or vendors. And it does not include agreements that are outside of an employment relationship. It also does not include agreements made in connection with the sale of a business, where you're selling substantially all the assets or ownership interests. However, in order to meet that classification, the party that is restricted has to be a significant owner of the business and receive significant consideration or benefit from the sale. And you'll note that a significant owner, a member of a partner in the business entity, a business entity can be a person, a group of persons, an LLC, a corporation. So it does not have to be a formal business. If you're running a business as a sole proprietor and you sell it, you can be subject to a non-compete. And again, it does not have to meet this statute. It does not include confidentiality agreements. It does not include invention assignments agreements. And it does not include non-compete agreements that are made in connection with the separation of an employee. So normally you have an agreement with an employee at the beginning of the employment, you have them sign a non-compete, a confidentiality, which contains confidentiality, non-solicit, all of that. The non-compete provision can be enforceable if it meets the Act. If you don't have one of those and you terminate an employee and say, I'll pay you X in order to non-compete, and if you won't compete and sign it, at that point in time, you can do that and you don't have to comply with the Act. Obviously, that's a more difficult situation because the employee is not bound at the time you terminate. There's some nuances which I'm going to go through that can maybe help you position into that so that you can get that non-compete, particularly when an employee is terminated without cause, and we'll talk about that in a minute. But essentially, if you enter into a non-compete at the end of your employment, that will be enforceable. The one caveat is you have to give the employee the right to rescind the agreement within 7 business days. In addition, the other thing is, I know some of you have seen provisions where you have the employee agree not to reapply under certain circumstances when people are terminated. That also is not within the Act, and those are enforceable. Let's talk about how you make a non-compete enforceable. So the minimum requirements for enforceability are you need a signed written agreement, you need to provide the agreement before the offer, or 10 days, business days before the employee commences employment. And the reason for that is to give the employee time to consider it. Essentially is why they've set that up that way. If you enter into an employment agreement which contains a non-compete after the employee starts at the company, you have to give the employee 10 business days notice with regard to the agreement. And then you also have to provide fair and reasonable consideration. And that fair and reasonable consideration has to be more than just continued employment. That would not be sufficient. You would have to give them a bonus or some other consideration in order for them to sign. And this is after they've already been employed. The non-compete agreement cannot be broader than necessary. So again, it's the same 3 factors that you look at, we looked at before to determine the enforceability of a non-compete, which is it can cover, it's there to protect trade secrets, it's there to protect confidential information, and it's there to protect goodwill. So you want to have it crafted such that from the agreement you can certainly substantiate that it's reasonable in terms in order to protect those 3 things. It doesn't go beyond that. You're not trying to limit an employee beyond protecting those legitimate categories. The agreement cannot exceed 12 months. That's very new. Typically, many companies had employment agreements with non-competes that went for 2 years, 18 months. Well, now you're limited to 12 months. It has to be limited in a geographic scope. That geographic scope has to be a reasonable geographic scope. Generally, if it's an area in which the employee worked, was materially present, provided services within the 2 years prior to termination, that would be presumed to be reasonable. So again, that's factually, you got to look at that to determine whether you need to limit the scope, the geographic scope within the agreement when you're drafting it in order to make sure it's enforceable. Going back to the 12-month restricted period, that period can be extended in certain circumstances. Basically, if the employee breaches his fiduciary duty or physically or electronically takes company property, you can then extend that agreement. So what I'm seeing now in agreements is there are clauses that expressly set that out, that if you breach your fiduciary duty or you take company property, then the non-compete will automatically expand to 24 months. But you can't exceed that. Next is it needs to reasonably prescribe the activities. And what we mean by that is, what was the employee doing? If you're in sales, then we're going to limit you with regard to sales. We're not going to prevent you from competing in some other area of a competitive business. So again, you've got to look at the facts. What's this employee doing? Be a little bit more specific within the agreement to specify this is what we're restricting you from doing versus just a broad, you can't compete for the company. So if I was in sales and now I'm going to be in research and development, the employee would have, I think, an argument there that the non-compete, if it covered that, would not be enforceable with him participating in the research development and not in sales. All of the non-competes have to be supported by consideration. The statute provides that if you have a garden leave clause, that's sufficient consideration. And then it has this nice broad term, or other mutually agreed consideration. Nobody knows what that is yet. There's no case law on this, so you'll see in agreements now people are, and I'll give you some examples, are playing with this to try to meet this requirement and not have to be stuck with the garden leave clause. Well, what's a garden leave clause? A garden leave clause is basically the 2 bullets below. 50% highest salary within 2 years, that's what you have to pay the employee in order to meet the garden leave clause requirement. So it's half a year's salary. And you pay it pro rata over the period of the restriction, which would be the 12 months. And it has to be treated as if it's wages. In other words, you pay it along with wage payments. You do it with payroll. You treat it as if it's a wage payment. The employer cannot unilaterally discontinue payments of this garden leave clause unless the employee breaches the agreement. So you're bound in to pay 6 months over 6 months salary over 12 months, and you can't unilaterally terminate those payments unless the employee breaches his fiduciary duty or breaches this garden leave clause. I had mentioned that 24-month extension. If you can do that 24-month extension as a result of the breach of fiduciary duty or as a result of the taking property, you do not have to pay during the extension period. In what circumstances are the agreements not enforceable? One is they're not enforceable against a non-exempt employee. So that means any employee who is eligible for overtime, no enforceable non-compete against that employee. They're not enforceable against undergraduate or graduate students in internships or short-term employment. They're not enforceable against employees that are terminated without cause or laid off. So you can have an agreement signed with the employee, exempt employee, and then you decide it's not working out, I terminate them. There's no employment, no non-compete as to that employee. Again, we're going to talk about ways to maybe get around that to the extent there's a concern there. But that's a big, big loophole. That's a big change before what we used to have under the old law. And you can't enforce it against somebody who's age 18 or younger. Interestingly, even if you have a non-enforceable non-compete, it does not void your non-solicits or your of employees or of your customers. And there are circumstances where you could go into court to seek enforcement of a non-compete, even if it was non-enforceable. That's still allowed. I think those circumstances would be pretty limited and hard to meet, but that is a possibility. And you can't avoid the statute and avoid these restrictions by putting in a choice of law. And let's say, we're going to apply North Carolina law, particularly as to an employee who was a Massachusetts resident on termination and was Massachusetts resident 30 days prior to termination. So you can put a choice of law in there, but it may not work. And certainly, even with a choice of law, courts may not enforce them depending. If you've got an employee who's really not working in Massachusetts, all the work they're doing is down in Texas, you may run into issues there just with the court. But under this statute, it expressly provides that if the person is a Mass resident at the time of termination and had been a Mass resident 30 days prior to that termination, if you have a choice of law of another state, it's not going to be enforceable. This statute is going to be enforceable. So, caution. The agreement needs to be carefully drafted to comply. So, I know we're up here, we always give you advice, but this is one area you really should at least talk to an attorney, even if you get an agreement set up, a form agreement, so it meets the requirements going forward. There are other statutorily required conditions that I haven't mentioned. I'm not going to bore you with the legalese. There are things about you have to have a right to put in there a right to consult with an attorney, issues with regard to consideration and whatnot. But again, that's why I really think you should go to an attorney to at least get a form so you can use it going forward. So what have I seen companies doing now as a result of this statute? There are people that in the agreements are now putting a lot of detail about what the consideration consists of, and that's to meet that other mutually considered consideration clause. They're putting in statements to the effect that it's employment, because I'm hiring you. These are ones when you're hiring an employee at the time. I'm giving you access to key relationships. I'm giving you the ability to participate in our benefit plans and programs. And it's not just, and I'm giving you, $30 or $100 or whatever. So they're really trying to emphasize all the things we're giving you as part of it as an employee to say that's the consideration for this. Will that be enforceable? Remains to be seen. We'll see what a judge will do with that. What I also see is that people are structuring agreements so that there's an execution of a non-compete upon termination. Now, you can't put in the agreement, when I hire you, you're going to execute a non-compete when I terminate. I don't think you can, because you're agreeing ahead of time. The agreement has to be in connection with the termination. So what I've seen is people will say, I'll pay you a severance on the condition that you do 3 things. You return property, you sign a release, and you execute a non-compete. That I think would work because they haven't agreed yet, and at the end of the day, when I'm terminating you, I'm saying, I'll give you X if you give me Y. So that's another way people have done it. Another way people are attacking it is the definition of cause in your agreements. This is usually a tug and pull between employer and employee. Employees want very restricted cause, very limited, very small, short. I committed a crime. Employers want it broader, and now what employers are doing more are putting in a clause to the effect of, if you fail to perform or your performance is not adequately satisfactory to the company. That's a pretty broad loophole. That's effectively, you're not making the grade, you're gone. And then the reason to do that is to say, I can point to the agreement and say it's cause. Now again, could a court twist with that? They can, but at least if you define cause to include just a termination when somebody's not working out, you at least have that argument. Therefore, if it's not without cause, it's enforceable. I'm seeing people put in provisions that provide that, well actually this is a thought I had. I haven't seen this one yet, but this is a thought I have, is that you have a good reason clause. If people are familiar with that, good reason clause, the employee can terminate if you reduce their salary or if you reduce their authority and responsibilities. So what an employer, I think, could do that could work is you could reduce, even if there's a good reason clause, you reduce the salary or you reduce the person's authority, then the employee raises their hand and says good reason and terminates. They terminate. It's a voluntary termination by the employee. It's not a termination without cause, in which case the argument would be that the non-compete is enforceable because the employer didn't terminate without cause. Again, I'm not sure that would be enforceable. I'm sure there would be some arguments to say you're effectively compelling the employee to terminate, but that's a possibility to use if somebody wants to be on the cutting edge. I'd be happy to draft it for you. The other is you tie the severance to, obviously, the non-compete. So we'll pay you a severance, but only if you sign a non-compete. Most employees are going to be sitting there weighing the benefits of signing a new non-compete, a termination, or taking the severance, or saying, no, I'm going to go work for the company. Obviously, if you terminate somebody and they aren't in a position where they're taking a job, they may be more apt to say, fine, I'll take the severance. It gives me time to, I'm not going to compete. I got to go find a job anyway. I'll take it, and that would give you that protection. And then the last, I think I mentioned it earlier, is people are putting in provisions that expressly provide for that 24 months kick-up if you take property, which helps you enforce people not taking your property when they leave, documents and whatnot. So that's it for the non-compete. If anybody has any questions right now, I'll take them. If not, I'll move on. So this is really just to make sure people are aware. I've talked to a few clients who were not aware of this. There's a there's a health insurance responsibility disclosure form that every company has to fill out and complete by November 30th. It's the employer's responsibility. You can have your payroll company do it, but you need to coordinate to make sure it's done. It's applicable to employers with 6 or more employees in any month during the 12 months prior to November 30th. You have to fill that out, whether you're offering health insurance or not. It's administered by Mass Health and the Mass Department of Revenue through Mass Tax Connect. You go to the web portal, you sign on, and you fill out the form. The purpose of this is to inform Mass Health about what employers have for their health insurance offerings, so they can determine even if a company has an employer-sponsored health insurance program, whether or not the employees are eligible for premium assistance. So there's there's a benefit here to your employees by completing this form, because some of your employees can possibly get this premium assistance, and it makes it easier for them to do it. It avoids you having to fill out an application form with them later. So it is helpful and beneficial. It doesn't take much to do it. You go online and complete it. And this helps Mass Health if somebody applies, whether or not they're eligible or not, because they've got the information from the employer already. Where do you find the form? You go to this web portal. So if you don't have it, I would encourage you to go to it. If you haven't created an account, do it, log on, and then complete your form by November 30th. That's all I have.
Good morning, everyone. Today I'm going to be talking to you about the new Massachusetts Paid Family and Medical Leave Act. Now, the act was signed into law in June 2018. The law has two major components, contributions and benefits, but today I'm going to be talking primarily about contributions because there are some deadlines coming right up relating to contributions, whereas the benefits don't go into effect for another year and a half. So beginning in 2021, employees and some independent contractors may take up to 26 weeks of paid leave for qualifying medical or family events. Now, the benefits will be funded by a new payroll tax, and that is effective July 1st of this year. So it's about another month and a half. And employers with a workforce of 25 or more will be required to contribute to that as well. The program is administered by a new state agency that was developed for the purpose, the Department of Family and Medical Leave. The act covers just about everyone. It covers all Massachusetts employers. It covers all employees who work in Massachusetts, whether they be full-time, part-time, or seasonal. All self-employed workers are eligible to pay into the program and receive benefits if they choose. And some independent contractors are required to pay into the program, which I'll get to in a minute. Many of you have probably dealt with the FMLA, and there are similarities between the two, which I've listed here. Among those are leave is available for the same medical and family reasons. It can be continuous or it can be intermittent. And the employee needs to maintain their health insurance benefits, and they are required to be returned to their position when they return from leave. But even with those similarities, paid family leave is not just FMLA that's paid. There are significant differences, and the most important is that this program is administered by the state government, not the employer. So the employer is going to have a lot less control over the benefits, who takes leave, and when. It's also much more generous. It's a 26 weeks of paid leave per 12-month period, as opposed to 12 weeks. And that 12-month period looks forward from the first day of leave. And that's different from the FMLA in that with the FMLA, employers have a few choices about how they can calculate that 12-month period. It's also more generous in terms of what a family member is. It broadens that term such that there will be more opportunities for employees to take this leave than they would under FMLA. And employers cannot require their employees to exhaust their accrued paid leave. And I put exhaust in quotation marks here because the regulations have not yet made clear what exhaust means. Whether that means, could you require them to take all but one day of their accrued paid leave? It's not clear yet. Hopefully the final regulations, which are due out by July 1st, will make that more clear. So the first requirement for employers under the program is providing notice to your workers by June 30th of 2019. There's both a poster requirement and a written requirement. The poster is available on the DFML's website. I've also included it in your packet so you can see what it looks like. The template itself is in English, but if you have 5 or more employees who speak a language other than English, you need a translated version. The website does have about 12 languages available in a translated version. So you can print that out, laminate it, stick it on the break room wall or the cafeteria room wall or wherever your posters like this are usually kept. There's also a written notice requirement. By June 30th, you need to provide all of your workers, so employees and contractors, with a written notice of their rights and obligations under the law. Again, templates are available on the DFML's website, and there are 12 languages available other than English. Now these, for the current employees and contractors, the template requires them to sign and acknowledge that they have received this notice on or before June 30th, 2019. So that's an important deadline, and you want to make sure you get it to them before then, so they can sign it, acknowledge that they received it, and return it to HR. Also, going forward, every employee and contractor needs to get that written notice. Now, moving to the first major aspect of the law, contributions. These are going to start on July 1st, 2019 with an initial payroll tax of 0.63%. That's up to the Social Security limit, which right now is about $133,000. The total required contribution is split up into a medical leave contribution and a family leave contribution. The medical leave portion is more. If you have less than 25 covered workers, the total required contribution can be totally come from your employees. If you have more than that, it's going to come from you as well. And that calculation, what portion needs to come from you, comes out to about half of the required contribution. So it's going to be about 0.31% of the employee's earnings is going to need to be paid by the employer. And the next slide here just breaks down that contribution for you. You can take a look at it. This chart was provided by the Department of Family and Medical Leave. Now, if you have less than 25 covered workers, that bottom line does not apply to you because the employee will be paying for all of it. So to determine how much this is going to cost you and your employees, there are 3 questions that you need to ask first. Do you have to pay a share of your employees' required contributions? Are the contractors who work for you required to contribute? And do you have to pay a share of their required contributions? And the answer to all of these depends on your workforce size, as the law refers to workforce size. And this is, because it was a regulation set forth by the state, it is unnecessarily complicated. And it is confusing, and so while I'm going to quickly go through it, I also have a couple of examples that should help explain it. First, there's a difference between your total workforce and your covered workforce. Your total workforce is every employee or contractor who works for you, and covered workforce is the amount of workers who have to pay into the program and will be eligible for benefits. Now, all W-2 employees are covered workers. They all will pay into the program. They're all eligible. Contractors are covered if they make up more than 50% of your total workforce. And if so, you're required to withhold earnings. If they are more than 50% of your workforce and you have a workforce of 25 or more, you need to also contribute on behalf of these contractors. Sorting that out, if we take the example of an employer who has 15 W-2 employees and 10 contractors working for them, and by the way, this is an average that goes back over the past calendar year from from January 2018 to December 2018. So this employer has 25 workers total, and because the contractors make up less than 50% of their workforce, only the 15 W-2 employees are covered. Now, that means that the employer is responsible for withholding each employee's total contribution from their earnings. They don't have to withhold any earnings from the contractors, and because their total workforce is because their covered workforce, is less than 25, they're not responsible for paying any portion of anybody's contribution. In the next example, the employer has 10 W-2 employees, 16 contractors for a total workforce of 26. And because the contractors make up more than 50% of the workforce, the employer needs to withhold a portion of each employee's and each contractor's contribution from their earnings. And because the covered workforce is more than 25, they need to pay a share of both the employees and the contractors' required contribution. And finally, an easier one with 5 W-2 employees, 11 contractors. There's only 16 total workers and there's 16 covered workers. So the employer has to withhold from both employees and contractors, but they're not responsible for paying any portion of that. Beginning in October 1 of 2019, these need to be remitted to the department through Mass Tax Connect, and that's going to be for the July to September quarter. And going forward, they will be remitted quarterly. Now, benefits don't come around until January 1st of 2021 for eligible covered workers. I say eligible because there is a financial eligibility test. It's a very low bar. It's the same as unemployment, so most people are going to qualify for this. Covered workers can take up to 20 weeks of paid medical leave per year, 12 weeks of family leave for a new child, 12 weeks of family leave when a family member is deployed or is about to deploy, and 26 weeks to care for a family member who was injured or became ill on active duty. Now, important to note that there's no requirement that an employee or worker has been working for you for a certain period of time, so even a very new employee can take these benefits. And the max weekly benefit, by the way, is $850. So this is just partial wage replacement. Covered workers as of July 1st, 2021 will be able to take 12 weeks per year to care for a family member who is ill. But again, each worker can only take 26 weeks per year total in aggregate. A few brief notes on when an employee takes this leave. The employer needs to continue paying health insurance and benefits. They need to restore a returning employee to same position or similar, same pay, same status, all of that. And the employee does need to give 30 days notice if it's feasible. And you can make a requirement that says an employee who's gone out on medical leave has to certify that they are fit for duty before they come back. And now we get to that portion of what happens if an employee or the state believes that an employer hasn't complied with their obligations. Now, the biggest minefield here is retaliation. We all know we can't retaliate against workers who exercise rights under, for example, FMLA. And here it's under the PFML. However, here there is a presumption of retaliation if within 6 months of the employee returning, an adverse employment action is taken against that employee. So if within 6 months of an employee returning from leave, you discipline them, you demote them, anything along those lines, you are presumed to have retaliated against them for them taking that leave. This can be overcome with clear and convincing evidence, but that is a higher standard than is required, for example, if you have an employee claim that you discriminated against them. So There's also no administrative filing, so they don't need to go to the MCAD first or the Attorney General. They can go straight to court. If an employer is found to have retaliated, in addition to being liable for back wages, emotional distress, you can also potentially be liable for triple damages, and that's at the discretion of the court. So the court gets to decide whether they think you should have to pay triple damages or not, and attorney's fees. There is also a penalty component separate from retaliation if you do not pay when you're required to contribute, and that is 0.63% of your total payroll plus paying the contributions that were owed. I'm very briefly going to mention exemptions for private plans. There is a provision of the law that provides for exemptions for employers who want to put forth their own benefit plan. However, it doesn't look that it will be very popular because your plan has to provide benefits that are equal to or more generous than the law. It has to be available to all employees, and it even has to be available to former employees for up to 26 weeks after they leave your employment. So while some employers may want to apply for an exemption if it's important to them to have great control over the process, they will be paying for all of this. So the exemption portion is not likely to be particularly popular at this stage. So we have reached next steps for the immediate future. First, if you haven't already, contact your payroll administrator immediately to make sure that they are set up to start withholdings on July 1st. And that if, as an employer, you're required to contribute to that the withholding takes your contributions into account. Also, you'll need to display and deliver notice to your employees by June 30th. You also want to add a new PFML policy to your handbooks so that expectations are clear. And you'll want to add that required written notice to your new employee orientation materials. This last slide here is just a cheat sheet of important dates and deadlines that you'll want to make sure to be aware of. Are there any questions?
So I have a Southern New Hampshire office. So we have employees that live in Massachusetts, primarily work in New Hampshire. I have employees that live in New Hampshire, primarily work in Massachusetts, and the same thing in Rhode Island, but Rhode Island has their own
Right.
issue. So what do I do? Do I include them as covered employees? Do I not include them? Do I ask them if they want to be included?
At this stage, a W-2 employee, for example, in Massachusetts, is anyone who's issued a W-2 form for performing services in Massachusetts. So again, there are vagaries to that, how much services, generally primarily their services are based in Massachusetts. So even if they live somewhere else, if they're performing services in Massachusetts, primarily.
I have the manager lives in Massachusetts, works in Manchester. Primarily he works in Manchester.
Then no.
Assume that there will be paperwork, just like the FMLA has forms that we send to the employees and to the doctors. Do you anticipate that that's going to happen here in Massachusetts?
Actually, because this is administered by the state, the employee needs to send their paperwork, their application, their medical certification to the state, and the state will decide whether or not they get to take leave and receive benefits. Now, if an employee applies for benefits, then the employer will need to submit certain paperwork about how long the employees work there, the leave that they've taken, how much they make, that type of thing.
And with that, will we still have to send FMLA paperwork, even though it's going to kind of be moot?
There is some confusion about that right now, and I say that because the PFML is supposed to be concurrent with other leave like FMLA, like earned sick time. But because there are some different requirements for FMLA, it is possible, at least now the way the law is structured, that an employee will be eligible for this leave, but not for FMLA. So it would be very difficult for those to be concurrent if they're eligible for one but not the other. So from the way it looks now, and again, they may clear this up in the final regulations, it looks like you may need to split that paperwork, you may not. In the boy in the back?
On the workforce side, when you're calculating that, is that full-time equivalents or?
Nope, it is everyone.
Because we have some 1099s who do very little work, a few hours a year for us, but if you add them all up, they could be in numbers.
And again, as of right now, with the regulations, it is all employees. They're not making it full-time equivalents. But again, there are still questions. There will be hearings, public commentary before the final regulations, and an issue is clearing up some of that confusion with the 1099 employee only does a few things for me.
I'm going to transition away from paid family and medical leave into wage and hour issues. First, I'm going to talk about federal issues under the Fair Labor Standards Act, and then I'm going to handle a few issues arising under the Massachusetts Wage Act. When some of you see this title, DOL Proposed Regulations, you might have some flashbacks, some shudders to a couple years ago. I'm sure a lot of you worked very hard to bring your companies into compliance with updates to the salary level test a few years ago, and then found out that it was not going to come into effect. Well, a few years later, there might be some new regulations that are coming down the pipeline. We just wanted to make you aware of them. Starting at the most basic, the federal statute on point is the Fair Labor Standards Act, known as the FLSA. It requires that all employees, unless they're subject to an exemption, are paid a minimum wage and overtime pay. Overtime pay is known as time and a half. It's a premium rate, 1.5 times the regular hourly rate for every hour worked more than 40 in a given work week. That applies to all non-exempt employees. So I'll quickly address what makes an employee exempt. In order for an employee to be exempt under the FLSA, they must meet a 3-pronged test. That's set forth in painstaking detail in the DOL regulations. I'm going to try and simplify it. There's 3 prongs to the test. The first is the salary basis test. That means that the employee must be paid a fixed and predetermined amount that does not depend upon when the employee is in the workplace. If the employee is ready, willing, and able to work, then they must be paid for that time to fit under the salary basis test. The second is the salary level test, meaning that there must be a threshold met in terms of the remuneration to the employee through a salary. And then the third is the duties test, meaning that the employee's primary duties must be of an exempt criteria. Those are typically known as the white collar exemptions, the professional, administrative, or executive exemptions. There are several others under the FLSA. Those include computer sales, computer as well as outside salesperson. There are about 20 to 25 different exemptions under Massachusetts law as well, and some of them are as I guess difficult to decipher as you work for an educational institution. So yeah, you need to be careful about that, who's exempt versus non-exempt. So the proposed rulemaking that the DOL has come up with, the DOL is responsible for enforcing the FLSA, relates to the salary level test. In 2004, the salary level test was set at $455 per week. Extrapolating that over a 52-week year, it's $23,660 per year. So that meant that any employee that earned less than $455 per week in salary was non-exempt, and that was regardless of his or her duties. In 2015, the Obama administration's Department of Labor proposed increasing the salary level test to a rate of $913 per year, or $47,476 per year, and that was scheduled to become effective in May 2016. It was eventually pushed back to December of 2016. Basically, it was doubling what the salary level test was, and that is probably why a lot of you were looking at your workforce and seeing some employees who had easily cleared the salary level test who are no longer meeting the salary level test, and probably worked with a few of the lawyers in our office to address that. Hope you saved your notes. Now, within a few weeks before this was going to take effect, the federal court, a federal district court in Texas, enjoined the proposed salary level test. They entered an injunction preventing the Department of Labor from enforcing that. It was never implemented. The election in 2016 led to the administration going a different direction, obviously. So as we sit here today, the salary level test is still at the 2004 level, $455 per week, $23,660 per year. Within the last few months, the Trump administration's Department of Labor has filed a notice of proposed rulemaking to raise the salary level test. You'll notice that while the Obama administration proposed raising it by about $24,000 per year, this is roughly $12,000. So it's basically about 50% of what the initial rulemaking was back in 2016. So this proposed rule would raise the weekly salary level test to $679 per week, or extrapolated over a 52-week year, $35,308 a year. So it's about half of what was initially intended back in 2016. While the 2016 change was going to affect millions and millions of employees, this will only affect 1 million workers, make 1 million workers now eligible for overtime premium pay. And potentially some of your employees will be impacted. In 6 days, a public comment period that the DOL is required to have under federal law will close. Stakeholders, lobbyists will be providing their input as to whether they agree or disagree with that rate. You're welcome to check it out. That's why we've provided the link if that's of interest to you. There are a few additional proposed changes as well that I wanted to highlight for you. The first relates to highly compensated employees. Under the Department of Labor regulations, highly compensated employees have a relaxed duties test. The idea being that if an employee is making a certain level of earning a certain level of pay, then the DOL does not need to scrutinize whether their duties are exempt as highly. So the highly compensated employee's salary level is going to raise from an even $100,000 to an uneven $147,414. So if you have employees that are exempt under the highly compensated exemption, then you'd want to look at their duties if they're between the $100,000 and the $147,000 to make sure that under a relaxed duties test, they'll still be exempt. Otherwise, they might be non-exempt and eligible for overtime. The Department of Labor is also committed to a periodic review of the salary level test to make sure it goes up as cost of living increases. Previously in 2016, the Department of Labor proposed automatic increases as time goes on. This is just I would say, nebulous commitment to look into it periodically rather than tying it to any sort of cost of living or any formula. And finally, there's going to be some flexibility relating to the salary basis test, allowing 10% of the salary level to be satisfied by non-discretionary bonus and incentive payments. So that's to give employers some flexibility. If anyone has any questions about FLSA or this rulemaking, I'm happy to answer them. Otherwise, I will transition to the Massachusetts Wage Act. The Massachusetts Wage Act is very dangerous for employers in Massachusetts. It's unique amongst the states in that a violation automatically results in triple damages to an employee, as well as attorney's fees and costs. Once an employee has filed an action in Superior Court or in federal district court, they are entitled to triple damages even if there's been a late payment of wages. I will go over what is a wage and what is not a wage. In addition, under the Massachusetts Wage Act, it's spelled out that a president, treasurer of a corporation, as well as any officers or agents having management of such corporation are considered employers under the Wage Act and can be sued individually for a company's failure to pay wages. So if you have a company that's insolvent or bankrupt, a plaintiff's lawyer will certainly go after the individuals that he or she is able to go after to try and collect the wages that were not paid. The Massachusetts Wage Act requires that an employee who is discharged from employment, meaning the termination is involuntary, is paid all wages in full on the date of discharge. So saying we're going to put your check in the mail or we'll get you at the next pay period, that is playing with fire. And for a Massachusetts employee, and especially for companies that are not based in Massachusetts and don't understand that, are used to how other states operate, this can lead to some danger. And I'll explain sort of the parade of horribles for you later on. You cannot retaliate against an employee who complains about an alleged failure to pay wages as well. I would hope that none of you would do that anyways, but just if you do happen to discharge or otherwise take adverse action against an employee for complaining about a failure to pay wages, you are in violation of the Massachusetts law. So what is a wage? Meaning what must be paid on the date of discharge? What can be subject to treble damages? Base compensation is a wage. I think that's pretty self-explanatory. If it's a salary, hourly rate, draw against commissions, those are wages. Accrued vacation or paid time off, that is considered a wage. Once an employee has earned vacation time, that employee must either use it or be paid for it. Now, one thing to be clear about is that there can be a cap on the amount of vacation or PTO that an employee can accrue, as well as employers can have a use it or lose it policy for vacation or PTO, but that needs to be in writing, it needs to be communicated to employees, it needs to be clear, it needs to be enforced uniformly. And finally, commissions are wages. I will go through the difference between a commission and a bonus in a minute, but commissions are wages, bonuses are not wages. Two other categories that are not wages are sick time and severance. Those are not considered wages. I want to be clear that I hope no one takes away from my presentation that you can decide not to pay severance because of this presentation. I'm just being clear that severance is not something, if there's a failure to pay, can result in treble damages, president, treasurer, and managers of the company being sued for. It's just, those are not wages, but still, if you owe them to your employees, please pay them. So going through the difference between a commission and a bonus. Under the Massachusetts Wage Act, a commission is a wage if it is definitely determined and due and payable. So those are, and I'm quoting directly from the statute. What definitely determined means is if it is subject to calculation. So if you have a commission plan and it says that an employee will get a percentage of a sale and that sale has been made, it can then be calculated. You know that if you have a 40% of a sale of a gross sale commission plan and the sale is $10,000, the employee has earned $4,000. Due and payable means that all contingencies for payment have been satisfied. So that means that if you say we need to wait a year to make sure that the client doesn't terminate the contract before the commission is paid, and if the client does not terminate the contract, then you are owed the commission. That is the type of thing that makes a wage due and payable, rather than just something that the employee has in the process of earning. And that requires a very close review of your commission plan to make sure it's clearly articulated. We have a case currently pending where there's an ambiguity that's being exploited by a departing employee for that. Commissions in general, and this is very much in general, are non-discretionary and they're relating to the completion of a sale or closing of a transaction, relying on a commission plan. A bonus, on the other hand, is generally discretionary. It is usually tied to either some sort of anniversary or date or a company-wide performance. So if you provide your employees with a year-end bonus, that is not going to be a commission. That's not something that the employee earned. It's just something that came when a certain date passed, as well as if a bonus is tied to a company's performance. If a company meets a certain threshold for revenues, that's not a commission for the employee. So I would say, in general, as a rule of thumb, if this type of compensation is tied to individual performance, work on specific deals, that's typically a commission. If it's tied to company-wide performance, that's typically a bonus. So it would not be considered a wage under the Wage Act. Now, I have a little shrug emoji, because if you're a little confused by it, you aren't the only one. This has caused courts some confusion. This issue is frequently litigated, whether we have a commission, whether we have a bonus, because obviously the pot of gold for an employee is to prove that they've been deprived of wages. That gives them treble damages, attorney's fees, and costs. If it's a bonus, then they bear their own attorney's fees and costs, and there's no mandatory multiplier for the damages. Courts do recognize that there's a gray area between the commission and the bonus. The one thing I would caution about is, if you tell your employees, we're going to give you a bonus, but in reality it's a commission, that's not going to protect you. So how you title what the compensation is not really going to matter to a court. It's going to be whether it's arithmetically determined and due and payable to the employee. So a few tips from the Davis-Mom employment law team about avoiding the dreaded Wage Act complaint. And it really is dreaded Wage Act, because it really has teeth. It is a huge piece of leverage for employees, and it can be downright scary. So the first step to preventing the Wage Act complaint is to promulgate and enforce written policies and ensure that they are in writing, that they are communicated to employees, and that they're uniformly enforced. Something that we've seen come up in the past relating to vacation and PTO policies is if there is ambiguity as to whether vacation is capped or if there's a use it or lose it policy. If it's communicated orally to employees, oh yeah, we don't cap it, if it's communicated orally, well, we're never going to cap it, we're going to reward you for taking vacation time, and then in writing it's ambiguous, then an employee will say, I have 18 weeks of vacation after 5 years of service. They might even say, I didn't take vacation because I thought I was accruing all this and having a nice little nest egg. So you want to make sure you also track your employees' vacation and PTO. If you want to have a cap or a use it or lose it policy, you need to make sure that's in writing and communicated to the employees. Commission plans as well, same thing. You want to make sure that they are well crafted, that any contingencies that need to be satisfied are in writing, provided to the employees, made clear. If one contingency is when the payment is received by the company, then you need to make sure that's in writing. Otherwise, you might get stiffed on a bill and your employee might still come to you and say, where's my commission? And you won't be able to rely on the commission plan if it's not put forward there. Another thing to do is, in HR, obviously, HR, you would have some familiarity with this. Managers, not in HR, might not have familiarity with the Massachusetts Wage Act. You want to make sure that they know that an employee who is discharged must be paid in full on the date of termination. And that includes vacation, earned vacation, and includes commission. Because a manager might say, oh yeah, we terminated so-and-so today, I just wanted to let you know. But if they've walked out without their last check, they might walk right into the Attorney General's office, get a right to sue letter, and bring a suit. Now, once they file suit, again, even if the check's in the mail, that check will only be an offset on the triple damages, and that can happen within a week. So I know that I think all of us in our practice, if we talk to an employee who's been discharged, I think probably one of the first questions we'll ask is, have you been paid in full? And if the answer is no, then it's okay, we have something to work with here to use leverage with your former employer. And I think any competent lawyer in Massachusetts will ask that. That'll be the first question. The other thing to remember is, obviously I think best practice is to work with an attorney when drafting severance agreements for employees. But if you want to do that internally, you want to make sure that a waiver of the Massachusetts Wage Act is spelled out conspicuously in the release. Otherwise, there will be a potential argument that they haven't waived the Massachusetts Wage Act claim. Typically, we put it in all bold. Happy to answer questions about the Massachusetts Wage Act. Sure.
If an employee has used more than their accrued vacation when they leave, are you allowed to take that back?
That depends on what your policy states. I think as a matter of the Wage Act is silent on that. Now, if you have a policy that there needs to be, the employee needs to pay back into the system, then that's one thing. If it's silent on that, then I would say no.
Paying the wages when somebody leaves, I get that. Most people understand, they give the check. The real danger, or a significant part of the danger, is with vacation and with overtime. And a lot of people still think that with overtime, all you got to do is pay salaried. You don't. You have to meet those three categories: administration, executive, or professional. And I'll just give you, and then, so that's one thing. And then the other issue is with regard to vacation time. I'll give you two examples within the last couple of years of cases that I was involved in. One involved a C-suite executive. The company did not have a clear use it or lose it vacation policy, and it cost them $500,000 because this employee had accrued. Another situation was with overtime. They had their job description. They thought they'd met the executive qualification because they said his job responsibility was to supervise. But those tests are based on the actual situation of the job. You can have a job description that says these are your duties, but if actually the person does not have those duties that fit the exemption, there is no exemption. And in this situation, you had an employee who supposedly met the executive. He would have had maybe $30,000 of overtime. To settle the case, it cost him $100,000. So you really, those areas you want to look at to make sure that your people are actually working when they're doing, and they fit the overtime exemption, they're performing those duties and responsibilities. In vacation, you've got a clear policy, use it or lose it. So that's all I wanted to say.
Regarding repayment of unaccrued vacation time at the time of separation, that you cannot automatically dock someone's pay. You're not going to want to withhold that from their paycheck, even if you have a signed agreement with them or a policy. You're going to want to ask them to actually write you a check. You can't just take that out of their pay, so be careful for that. All right. The treacherous waters of employee disabilities. We've gone from the Dangerous Wage Act to the treacherous waters of disability. This topic is an oldie but a goodie. I find that over the years, regardless of how experienced my clients are, HR professionals, CFOs, CEOs, managers who work with these issues, they always cause consternation because there are so many moving parts and overlapping issues. So today we're going to address these questions. When is an employee legally disabled? When is reasonable accommodation required? When is a requested accommodation not a reasonable accommodation? When is time off a reasonable accommodation? Is pay required for disability leave? And must benefits be provided during disability leave? So let's start with defining what is a disability. Actually, before I do that, let me talk to you about sort of conceptually how I look at this. I think of it as different pillars. And oftentimes it's easy to confuse the different pillars. But if you think of it as separate pillars, I think it's helpful. So the first is there a disability? The second is the employee entitled to reasonable accommodation? The third is, might that reasonable accommodation be time off? If that reasonable accommodation is time off, we then look at what other time off is the employee eligible for or entitled to, and might there be some overlap? And then we go to, is there a pay available for that time off? Which is pay for time off is a separate issue from whether the time off is available to the employee, whether they're eligible for that time off. So, disability defined. An employee is disabled when they have a physical or mental impairment that substantially limits a major life activity. And you can believe that there's tons of law on what constitutes an impairment and what is a major life activity. But in Massachusetts, there is a liberal interpretation of the definition of a disability, or in Massachusetts law, it's actually called handicap. And under that liberal definition, you should always assume that someone who has an impairment that has a substantial medical condition is likely to be considered a disabled person, and caution should kick in, and you should start looking at this very carefully, potentially talking to us. Of course, discrimination against someone with a disability, or in Massachusetts a handicap, is prohibited by both state and federal law. And you cannot discriminate against somebody in Massachusetts because of their disability, or because they have a record of disability, a past record of disability, or because they might be perceived as or regarded as disabled. So the non-discrimination prohibitions go well beyond the existence of an actual present disability and expand the scope. So that's something to keep in mind. So let's start talking about that second pillar, reasonable accommodation. Reasonable accommodation is your obligation to provide when a qualified disabled person needs accommodation, needs some kind of modification or adjustment in their work schedule, the manner in which they do their work, etc., to perform the essential functions of their job. A qualified disabled person is someone who is able to perform the essential functions of their job with or without reasonable accommodation. Now, what constitutes a reasonable accommodation? An adjustment or a modification that enables the disabled person to perform the essential functions of their job. And these can be very diverse, they can be creative. Reasonable accommodations can span physically adapted facilities, workspaces, or equipment, something as simple as giving someone a stool for their feet, or some kind of a pad to rest their wrists on, raising or lowering their workstation. Modified work schedules, sometimes that's pertinent depending on the person's disability and their particular individual medical needs. Modifying when or how an essential function is performed. Sometimes this can be trickier than it looks. For example, it may be that someone, for whatever reason, is unable to type, to use a keyboard, but that doesn't preclude them from, say, editing, drafting, revising documents, or working in their computer, because of course there's technology available, such as voice recognition technology, that could enable them to produce, to do the role that they're required to do, to produce the product that they're required to produce, even if they can't type in that example. So modifying how they perform the essential function is an opportunity to think about exactly what is the essential function and how can we be creative to get there. Also, of course, light duty, reduced responsibilities, and possibly, in many instances, time off. Okay. When is an accommodation not reasonable? It's not reasonable when the accommodation would create an undue hardship for you as the employer. And looking at undue hardship is just as all these disability and accommodation issues are, a very case-specific analysis. Your business, your operations, your financial wherewithal, the size of your business, the type of business, might this create a financial hardship? Might this create an operational hardship? Might the accommodation that's being requested somehow threaten or compromise the health or safety of the employee requesting the accommodation or others? All of these are important questions to ask to determine whether there may be an undue hardship. And then, in order to accommodate the employee, to provide the reasonable accommodation that's required, and to also meet our business needs, our legitimate business needs, we're required to engage in an interactive dialogue with our employees to determine a reasonable accommodation. To be very clear, the accommodation that is requested by the employee is not necessarily the accommodation that you are required to provide. You do not have a requirement under the law to give the employee exactly the accommodation that they're requiring. But you do have an obligation under the law to engage in an interactive dialogue to figure out that balance. How can the employee be enabled to perform their essential functions, and how can you avoid any kind of undue hardship on your business? So the open and ongoing dialogue with the employee is required. You can also incorporate additional information that you get from the employee, that you get from the employee's healthcare provider. You can also consult with appropriate experts and consult appropriate resources. And depending on the circumstances, you can require an independent medical examination. Now, an example of a situation where the specific accommodation requested was not legally required is a case that came up in Massachusetts a number of years ago, where there was a car mechanic. He worked in a body shop, and he had asthma, he had respiratory issues. And the accommodation that he and his physician requested was a certain kind of air filtration system for the shop, for the facility. And this case went all the way up through the courts, through the appellate system. And it turned out that the employer was suggesting an alternative. And that alternative was a filtration device that that individual employee could wear on their face. So it was much more financially feasible. It didn't take such a big financial hit on the employer to provide this. It was something that the employee could do. The employee and his physician had turned this down out of hand, had said this is an inconvenience and it's not fair to burden the employee in this way to have to wear this device. The court said it is fair, and based on a balance of the employee's needs and the employer's needs, this is an appropriate, reasonable accommodation, and providing that individualized reasonable accommodation rather than installing a facility-wide filtration system was absolutely reasonable and appropriate, and the employer was in the right in that situation. Okay. Oftentimes, time off is an appropriate, reasonable accommodation. And I know that's sometimes hard to get our heads around, because how can you perform the essential functions of your job if you're not there? Good point. However, an accommodation constituting time off for a reasonable amount of time, an amount of time that you can absorb operationally and financially, is absolutely required to be provided. So time off as a reasonable accommodation, this is where we go to that next pillar and look at other kinds of time off that employee is eligible for and how they may interact with your reasonable accommodation time off. Time off as reasonable accommodation may overlap with or extend other leave entitlements, such as sick time. Some companies have an extended sick time policy. Some companies have a medical leave of absence policy. Of course, there's the family medical leave, and we heard from Emily today, there's the paid family medical leave. And there's also parental leave. So we have to think carefully about how the need for accommodation can dovetail with or overlap with, potentially be concurrent with these other kinds of leave that the employee may be entitled to. And all of these require, of course, time off with job restoration rights. The whole point is that you're giving this person a hiatus, and then you are required to restore them to their job or to the same or similar job. Okay, how much time off is reasonable? An accommodation is not reasonable when it creates an undue hardship, right? That's a general rule. Indefinite time off is not reasonable. If an employee brings you a note from a doctor that does not specify a return date at all, that's completely open-ended, that by law is presumed to be an unreasonable accommodation. You want to enter into an interactive dialogue with your employee and get a better sense of when they're going to be ready to return. Because it's not realistic, of course. It's burdensome to you as an employer to have this completely open-ended leave, this open-ended absence. On the other hand, if you get a doctor's note that has an anticipated return date and a reevaluation that will occur by the healthcare provider at that point, that is considered to be a finite period of time that is allowable as a reasonable accommodation. So there may not be a definite time, But if there's an anticipated return date and an opportunity for that healthcare provider to reevaluate the employee's situation at that point and their need for accommodation and extended leave at that point, that is something that you need to work with and to provide reasonable accommodation for. Now, I say here at least 12 weeks off is a good rule of thumb. For those of you who are smaller employers who are not governed by the FMLA, I've always said, look at the FMLA. The FMLA provides 12 weeks for a serious medical condition. That's a good rule of thumb. We, of course, heard earlier that in Massachusetts, starting in January of 2021, people with serious health conditions will be entitled to up to 26 weeks of leave. That's a half of a year. And so it may be that starting in 2021 or even starting sooner, we want to readjust our presumption as to what is the expectation of reasonableness with respect to time off as a reasonable accommodation. Obviously, as far as running your business, we need to think creatively about maybe temporarily replacing this person, about shifting their job responsibilities temporarily to other workers. There's no question it can be very difficult and challenging when you've got an employee out and you're providing time off as a reasonable accommodation. Maybe time off is not required, and use that interactive dialogue. Again, be flexible, be creative. Maybe working at home is a possibility. Maybe working at home part-time is a possibility. Maybe some kind of modified schedule or light duty is a possibility. As we talked about before, maybe modifying the way in which essential functions are performed is a possibility. Are there accommodations that will enable your employee to be present, to perform at least more of their job functions than would be possible if they take a complete leave of absence? It's worth exploring these questions, and you're entitled as an employer to have that give and take with your employee, to bring in their healthcare provider and ask them appropriate questions to determine what can be done. So now we're into that next pillar, which is you've got your time off. Time off as an accommodation does not require pay. But we go to the next question, which is how can this time off be paid? And obviously this is a pressing issue for your employees in most cases. They want to take the time off. They probably, in this case, they need the time off, and they're concerned about not being paid. So what is your responsibility? Your responsibility is consistent with all of your other policies with respect to paid time off. So the reasonable accommodation time off in and of itself does not require pay, but there are a lot of other opportunities that an employee has to be paid depending on which other policies are available to them. So some or all of the time may be paid using accrued and unused vacation time or sick time, or if you have a paid medical leave policy. A sick time bank. Sometimes employers have sick time banks where employees are able to contribute unused sick time to that bank so that other people in need can use it to be paid for their sick time. Do you have a short-term disability policy? Do you have a long-term disability policy? Was there a workplace injury? Is workers' comp coverage available? These are all the different pieces that need to be looked at to determine, based on the size of your company and your policies, how an employee can get paid, if they can get paid, for some or all of their reasonable accommodation time off. Are they entitled to benefits? While they're on this reasonable accommodation time off, they do not accrue any benefits. Just as if they're not working, they're not accruing their sick time, their vacation time, etc. However, they are entitled to health coverage throughout the leave, as long as it's handled in the same way as it would be if they were actively employed. So you should require your employees to continue to pay their portion of monthly premiums for health coverage. In the event that the leave is paid, obviously that would be deducted from their paycheck in the usual way. In the event that some or all of the leave is unpaid, you should require the employee to actually write you a check and pay for their portion of their monthly healthcare premiums. As far as other benefits, for the most part, you have to keep in mind, even though someone's on leave and they may not be present in your workplace, they're still an employee. and they're entitled to all the benefits and privileges of whatever policies you have in place. But I would defer to the specific plans, insurance plans, retirement plans, pension plans, et cetera, to determine exactly what is required during that leave time. Any questions on disability issues at this moment? Yes, Joe.
Can you put a limit on can you set up a policy to limit how long the leave can be? So if someone is past their FMLA leave, they're past their long-term illness, they're on long-term disability. We currently don't have a policy in place saying that it's such and such a date. Can a policy like that be put in place?
No. You can't limit the amount of time that's going to be provided as time off for reasonable accommodation purposes on a broad scale, because each and every individual situation has to be dealt with based on the circumstances of that particular situation, that particular individual's needs, and the particular needs of your business related to that person's role. Yeah. Okay. So let's move on to the EEO-1 form. This is a form that's required to be filed annually online with the Equal Employment Opportunity Commission. It is required to be filed by employers who have 100 or more employees. And it includes, as some of you probably know, data that's characterized with respect to race, ethnicity, gender, and job category for your workforce. It also applies to contractors, federal government contractors, and first-tier subcontractors with 50 or more employees and at least $50,000 in federal contracts. The form needs to be filed annually. The deadline is generally May 31st of each year. The reason that this is pertinent right now, there was an Obama-era initiative to add a component 2 to the EEO-1 form, which requires information about income in addition to minority classification or protected classification and job role. The idea is to look for the EEOC to be able to look at income information to identify pay disparities, particularly to address the well-established gender pay gap. So component 2 was proposed, there was litigation, now it's back on the table, and at this point, based on what's happened through the federal courts, employers who are required to file an EEO-1 will be required to file what they're calling component 2 information, which is W-2 income information and hours worked for both 2017 and 2018 as of September 30th of this year. That's the deadline for 2017 and 2018 submissions. Component 1 still due May 31st of this year in the usual way. And this brings up, I think, something interesting, many of you probably have thought of this, which is at the same time we have the new Mass Equal Pay Act, which requires a self-evaluation by employers to look at specifically information that is related to the gender pay gap problem. And what the self-evaluation under the Mass Equal Pay Act requires is for you to put together this same kind of analysis. You don't have to submit it to any government agency, but if you do an analysis that looks at how much people are paid, what role they're in, how many hours they're worked, and other benefits, conditions in terms of employment, in order to be able to compare apples and apples and determine whether you have any pay inequity problems. And if you address those issues internally, then the Mass Equal Pay Act automatically provides you with an affirmative defense against a pay equity, a gender pay equity claim. So the EEO-1 form is moving in this direction. Massachusetts, as usual, has already moved in this direction of all of us to do this evaluation to combat pay inequity, particularly gender pay inequity. The last piece is the BRAVE Act. The BRAVE Act is an act relative to veterans' benefits, rights, appreciation, validation, and enforcement. I just think it's so cool that they came up with 5 words That spelled brave. They did a good job. So the old rule, which many of you know, is that you were required to grant veterans a time off on Veterans Day and Memorial Day in order for them to participate in exercises, parades, other events in their community. And the old law was that if you had 50 or more employees, you were required to pay the employee on Veterans Day. The new law, as of last November, as of last Veterans Day, was that employers must grant leave to vets on Veterans Day regardless of what they are doing on that day. They do not need to show that they're participating in any commemorative event. For Memorial Day, assuming it's not already a day off for your company, for them to get the day off, they still need to show that they're participating in some special event. However, the new law has withdrawn the requirement for any pay for this time off for veterans. And now I'm happy to introduce my colleague David Rogers, who is a state rep and also of counsel with our firm, to talk to us about what's going on at the State House. To talk to us about the new crazy laws like the paid family medical leave that are coming down the pike.
Great. Well, good morning, everyone. Great to be here. Dave Rogers. I'm mostly a business lawyer, so mergers, acquisitions, licensing, but I also do some employment work. And in addition, I represent Arlington, Belmont, and Cambridge in the Massachusetts House of Representatives. And as I have done in past years, I'm going to talk a little bit about stuff that's going on in the legislature that's pending. It's impossible to predict with certainty what will become law, but we have a pretty activist legislature in our state, so there's always things brewing. A lot of what you've heard this morning came from the legislature: paid family and medical leave, the non-compete law reforms, and many others. And this session that's going on right now is no exception. There's a lot of things brewing that could have an impact on your business. We're toward the end of the program, so I'm going to go through things pretty quickly, but you should always know you can email me, you can call. I'm happy to talk to you about any legislation you have concerns about. And the final thing I'd say is, maybe you can't impact what goes on in Washington, but certainly here, feel free to contact your state representative or state senator, because we really do listen to what folks have on their minds. So if you have a business in someone's district, call them and say, I'm concerned about this issue. I guess the first, I don't have slides, but the first piece of legislation that's pending right now is called the Defense Against Abusive Waivers. And the theory there is a lot of employers, some number of employers have that packet of information they give to employees on their first day to sign, some of which includes a waiver of a right to a trial by jury, mandatory arbitration. And this would ban that. And it would also impose attorney's fees if employers try to enforce it. So I'm not sure if your companies have those or not, but if you do, it's something that's pending right now and could impact your business. Another bill that's pending that I think is a big deal is the anti-harassment, anti-bullying bill. And so when we talk about employment law, we talk about protected classes: national origin, race, gender, disability. Well, this would create an entire new class of protected employees, and that's anyone who is bullied in the workplace. And that's abusive conduct, can be insults, epithets, verbal or nonverbal or physical conduct of a threatening, intimidating, or humiliating nature, which creates an abusive work environment. So this is an entire new protected class of employees. So that's a big deal if this law were to pass. It also has a retaliation component, so that if someone asserts a claim or raises the issue and the employer retaliates in any way, that creates a claim. Now, why that's a big deal is when you talk to plaintiffs' employment lawyers, they'll say sometimes an employee cannot prove the discrimination on race or gender, or in this case, bullying, but they can prove retaliation. So this is a significant bill. It's got a lot of co-sponsors, a lot of senators and a lot of representatives have co-sponsored it. I should say the way a bill's introduced is rarely the form it's in when it's finally passed and gets to Governor Baker. So business interests are very well represented on Beacon Hill. They weigh in. And so the bill, you can't go and look to the legislature website and say, oh, it says this, so that's what the law will be. It will change a lot as it moves through the legislature. But that's one to keep your eye on. And then finally, there's a Fair Work Week bill. And that's requires 14-day advance notice of scheduling. So for employers who have a lot of employees who are wage employees, it would require a 14-day advance notice of schedule. When hiring a new employee, you'd have to give them an approximate schedule. If that schedule changes, they need to be updated. Employees would get predictability pay. So if that schedule changes suddenly on them, they can be paid. It would include changing time, location, adding hours. It would ban the so-called clopening shifts, which is where you both close and open. If you're a retail establishment, for instance, so Starbucks has already voluntarily said they would ban those shifts for employees. That bill has a lot of different piece parts. I won't go through all of them, but that would be significant for those of you who have a number of hourly wage employees. And I guess the final thing I'd mention is obviously now cannabis, marijuana, is legal in our state. And there is a bill that's been filed that would prohibit discrimination based on the lawful use of cannabis. So if you're an employer who does drug testing, it comes back positive, marijuana stays in your system a long, long time. I've heard different numbers, 21 days, 28 days, 34 days, whatever it may be. It would add another protected class of employees to Chapter 151B, which is our main anti-discrimination law, that those who test positive for cannabis, you can't refuse to hire them, you can't, any adverse employment action, not promoting them, firing them, you can't do any of that just because they test positive. Now, if they're impaired at work, obviously it's much different, very different. And that's an overview of some of the bills that are pending. As I said, if you ever have a question or concern, if you're a client of the firm or thinking of becoming a client of the firm or just here as a matter of interest, I'm always happy to answer any of your questions about what's going on in the legislature. So thanks for listening.